All right, welcome back. Now, by-elections have become quite controversial matters in Nigeria. For close to 5 months now, the people of Imo North senatorial districts do not have a representation in the Senate after the senator who was originally representing them died. Now, a by-election is actually taking place to replace the late senator since December 5th, and the All Progressives Congress was declared the winner of that election. That's by INEC. But the sticking point is who the candidate is. Two men are laying claim to the ticket, a former senator, Ararume, and Frank Ibezim. Now, both men have been jumping from one court to another in their bids to be declared the authentic candidate of the party and therefore the elected senator of that district. And trust our courts when it comes to election matters. They've issued conflicting orders over the case. On March the 18th, a federal high court in Abuja declared Ararume as winner of the poll and ordered INEC to issue him a certificate of return. But hours after that judgment, the state high court in Owerri, the Imo state capital, also gave another order now restraining INEC from recognizing Ararume as the winner. But Ararume claims that the judgment of the federal high court and later the court of appeal have conclusively disqualified Ibezim. The APC also denied fielding Ibezim as a candidate for the poll. Things, however, took a dramatic turn after the APC wrote a petition against 3 judges of the Supreme Court, accusing them of holding secret meetings with officials of the rival People's Democratic Party regarding the election disputes. As a result of the APC's petition, on the day Ibezim was to challenge his disqualification by the appeal court now, before the Apex Court judges announced an indefinite postponement of the hearing. Well, that's how things are. Even though the APC caretaker committee chairman, that's the governor of Borno's Yobe State now, has come out to apologize and denied ever making any accusation against the Supreme Court judges. That case is yet to be heard. And do not also forget, the PDP also has its own angle. It's insisting that the APC, by virtue of the various court judgments we've seen in this case, did not field any candidate in that election, and therefore their candidate should be declared the winner of the election. Now being joined by Oseloka Zikora, who is the spokesperson of the Frank Ibezim campaign organization. He joins us via Skype. I also have Barrister Tunde Falola, who is a counsel to Senator Ararume, who joins us from Abuja. Gentlemen, thank you very much for coming on the program. Let me start with you, Mr. Falola. What exactly is your client now? What exactly is your client relying on to say he is the elected representative now of the people of Imo North Senatorial District?
Thank you very much, the presenter. It is my pleasure to join you to discuss this issue. To start with, I think what we are witnessing in Nigeria now regarding the Imo North senatorial by-election is an abuse of court process and an abuse of power, executive power. I say this because the adversary, the other contender, that is the opponent to our clients, Mr. Frank Ibezim, has refused to give up in spite of the final judgment of a competent court that has declared our clients as the winner and as the candidate of All Progressive Congress in that by-election, and has ordered INEC to issue certificate of return to him within 72 hours.
Let me get this straight now. Sorry, before we go on, but let me get this straight. The judgment your client is actually relying on is the judgment of...
No, I'm coming. I'm coming. We are relying. I'm coming. We are relying on the judgment of Honorable Justice Taiwo
exactly,
of the Federal High Court, Abuja. Yeah. Now, to appreciate, what I'm trying to, put across, I think a brief history of the case, we give an insight into this discussion. As at the time we went to court, sometimes in December 2020, sequel to the unfortunate demise of the former senator representing Imo North Senatorial District, INEC scheduled a by-election for that senatorial district. Our client, Senator Ararume, fully participated as the candidate of the All Progressive Congress, APC, in that by-election. His name was forwarded to INEC. As at November 2020, his name was number 5, on the final list of candidates as, issued by INEC. That name was the name taken, by INEC as a candidate of APC for that election. Now, the election took place. Our client and his political party, APC, scored majority of lawful votes and satisfied the requirement of the law.
Very quickly, we also know that there was also another court judgment that disqualified your candidate before the election itself.
Yes. If you don't follow, this discussion in sequence, you might not get the. So as at that time, the judgment you are talking about, as at the time we went to court, there were 2 subsisting court judgments. One, judgment of the Federal High Court, Abuja, disqualifying Ibezim.
On the basis of his certificates, right?
On the basis of, presenting forged and a false statement and declaration regarding that by-election. That is the first judgment. The second judgment was the judgment that restrained, APC from presenting Ibezim. Though that judgment was, the latter judgment was set aside by the Court of Appeal on the basis that Ibezim was not made a party.
Was not
and
made
that you
party,
cannot,
yes.
I'm coming. Yes, you can't make judgment, you can't make order against somebody who is not a party. That is what the Court of Appeal said. Nothing more. That matter went to Supreme Court. That matter went to Supreme Court, and the Supreme Court have found that position, that you can't make order against a person who is not joined as a party. That's all. The Supreme Court never said return or Ibezim to be the candidate of APC. Court of Appeal never said Ibezim was the candidate of APC. Neither of the 2 judgments of this appellate court, neither of the judgments said that our client was not qualified. No. Conversely, the judgment of the Federal High Court, Abuja, delivered by Justice Echo, disqualify Ibezim because the court, found, as a matter of fact, that he presented forged statement and declaration. Now, on that basis, he appealed to Court of Appeal. The Court of Appeal have found that disqualification. Yeah. Now, the implication of this is that even as at the time he was preparing for that primaries, if any, there was nothing. He has done nothing because that judgment has set aside all the steps that he has taken, in preparation of that by-election. So there is nothing for him to stand on to lay claim and ask INEC to issue him certificate. That is number 1. Now, when the matter got to hearing stage before Justice Taiwo of the Federal Court, Abuja, we were asked as party before him to address him on the propriety or otherwise of all this judgment. We took time. We filed written addresses. All parties filed written addresses. And the court, having examined the Court of Appeal decision, the Supreme Court decision, has found, and rightly found, that there is nothing, in the Supreme Court judgment, which Ibezim is now laying claim to, that said he should be presented as the candidate of the APC. Conversely, the court found that even the Court of Appeal judgment that disqualify him has not been set aside. And as I speak with you now, that judgment of the Court of Appeal that affirmed his disqualification has not been set aside. Now, the question we ask ourselves is, can someone who has been adjudged to have violated the law, can you present him as a candidate? On what basis is he asking INEC to issue certificate of return to him? So definitely there's no basis. And in our own case, the judgment of Honorable Justice Taiwo is a final judgment, and that judgment took into consideration the various arguments by parties and addresses by counsel, and it came to a logical conclusion that our client. I'm coming.
Our client is. Before I go over to Mr. Oseloka, you mean
yes.
In that case that went to the Supreme Court, your candidate, your client did not ask the Supreme Court to make him the candidate of the APC? He did not ask that?
No, you see, there was no basis for that request in the first place. The reason is that what the Supreme Court decided
what I'm
was
asking, did your candidate actually ask? I mean, did your client now ask the Supreme Court to make him the candidate of the APC?
In that judgment,
in that case that the Supreme Court eventually ruled on.
Well, definitely, I wouldn't know because the matter was taken from a Owerri Federal High Court, and I was not in that matter.
Because from what I have and from what we have seen and read, your candidate actually, your client actually asked the Supreme Court to make him declare him the candidate, and the Supreme Court declined.
I'm coming. Assuming without considering that he made that request, and the request was turned down. Does that affect the case before Honorable Justice Taiwo? The answer is no.
Of course you're right. I'm coming. What I'm saying is that it has implications. But you know what? Can I just pause you here? Can I just pause you here?
It doesn't. Please let me for 1 minute. In 1 minute, please. In 1 minute, please. It doesn't really have any implication because the judgment, the case before Honorable Justice Taiwo was that, look, INEC haven't declared my party, political party, as the winner of that election, and haven't participated in that by-election. I, as a candidate of that political party, ought to be given that certificate of return, because the law is that where there is right, there must be means by which that right can be enforced. If I participated in that by-election and you declare my party, political party, as the winner of the election, and I was a candidate all through the process of the election, there is nothing stopping INEC from saying, okay, this is the certificate of return. That was the basis when we went to court and asked the court to exercise its jurisdiction under Section 251, Sub 1 and R of the 1999 Constitution. Because if you look at it, the refusal of INEC to issue that certificate of return to our client is in the realm of administrative exercise. And it's only Federal High Court that has jurisdiction when it comes to matters that relate to administrative action or executive action of federal government or any of its agency. So they have embarked on judicial abuse of court process. They have been going to federal court. Recently they went to High Court in Owerri to obtain an illegal order. The order was made without jurisdiction, and thank God the matter has been dismissed. The case has been dismissed.
For want of time, let's go to Mr. Seloka now. Mr. Seloka, let me hear your own side of the story. I mean,
yes, I will ask for one thing.
The courts, of course, have not helped matters in this case, to be candid, and the whole thing is sort of confusing, even though there's a clear pathway that one can actually see through. But let me get your own perspective now from the angle of your candidate.
Yes, Deji, thank you so much for having us. But let me state something. First, given that kind of time to be able to respond to the many issues he has raised. That's one. Two, just to correct the initial impression in your intro that said that the APC denied presenting the candidate, that is the Senator-elect Sir Frank Ibezim as his candidate. No, APC never denied presenting Frank Ibezim as his candidate. That was duly done on September 13th when APC presented Sir Frank Ibezim as the lawful candidate for the election. Sometime in October, Senator Francis Ararume went to the Federal High Court to get an order that Ibezim on the ballot, which Justice Ringim of the Federal High Court then granted him. However, that very court order was appealed against, and on December 4th, mark my words.
Yes,
on December 4th, 2020,
the Court of Appeal
before the election, the appeal court set aside the judgment of Ringim, which puts Senator Ararume on the ballot. By that ruling, Senator Ararume's candidature ceased to be because he was put out. That judgment set aside the judgment of Ringim. So it never happened. That means that the candidate that remained on the ballot of the APC as of December 5th, 2020, when that election was held, was Sir Francis Ibezim. So that's the matter as it is. However, let me address the issue of Justice Taiwo. Unfortunately, Justice Taiwo's intervention in this matter is a very strange intervention, in that we do not know why.
Is it strange, or it's a different matter altogether?
No,
even though they are related. So how is it strange?
I will let you know why it's a strange intervention, DEJI. I will let you know why it's a strange intervention. We don't know whether it's a pre-election matter or post-election matter that was brought before Justice Taiwo.
Obviously a pre-election matter.
The Constitution says that notwithstanding anything contrary in this Constitution, every pre-election matter shall be filed not later than 14 days from the date of the occurrence of the event, decision, or action complained of in the suit.
But why didn't you make that argument before the Court of Appeal?
It was made before Justice Taiwo. It was made before Justice Taiwo.
No, I'm saying, and during the appeal, what happened?
Robert SAN, appearing for Sir Frank Ibezim, made those arguments before Justice Taiwo. That he failed to take cognizance of that is what is strange to us. Also, the APC lawyer, Barrister Liu, also made those arguments before Justice Taiwo. So the issue there is that the occurrence of the event in the matter is the primary election of the APC that took place in August 2020. They filed the matter that they are talking about in December, clearly almost 3 months or 4 months after the occurrence of the event. That is not envisaged in the Constitution.
Well, but that is now, aside anyway, because this matter went from Justice Taiwo now. I mean, Inyang went up to the Court of Appeal. The Court of Appeal upheld that judgment and, of course, ordered that a certificate of return be issued to Senator Ararume before your candidate now filed another case, appealed against that now before the Supreme Court, which is where we are at the moment.
I'm saying that you pray, you listen to the genesis of the matter as you were patient enough to listen to
him. Go ahead.
So if it is not a pre-election matter, is it then a post-election matter? If it's supposed to be a post-election matter because it was filed after the election had taken place on December 5th, 2020, the Constitution says, that's the Electoral Act says, no election and return at an election under this Act shall be questioned in any manner other than by a petition complaining of an undue election or undue return, in this Act referred to as an election petition, presented to the competent tribunal or court in accordance with the provisions of the Constitution or of this Act, and in which the person elected or returned is joined as a party. In this part, tribunal or court.
Yeah, I understand.
In the case of presidential or governorship election, the Court of Appeal, and in the case of any other elections under this Act, the election tribunal established under the Constitution or by this Act. So
I understand. Yes.
We do not know. It's very strange why Justice Taiwo should entertain this matter. It's an abuse of court process. And really,
I understand your point, but that is gone anyway. You've gone beyond Justice Taiwo now. What about the Court of Appeal?
It's still under, because that's his matter. His judgment is already under appeal, and of course the judges, we believe that the Court of Appeal will dismiss that judgment with ignominy, because we would set aside that judgment. We set aside that judgment with ignominy. Let me say something. We are aware that on the issue of disqualification of Sir Frank Ibezim by a high court in Abuja, that is an ongoing litigation, sir. Once it's an ongoing litigation, until the final court rules on the matter, it cannot be taken as a final arbitration.
And of course, the case is before the final court.
Before the final court, that is the Supreme Court. And talking about Justice Taiwo's matter, let me say this. We duly informed him, he was duly informed, that this matter is already before the Supreme Court. And here the Supreme Court on such issue, the judgment of the Supreme Court, as recorded way back by justice.
But can I ask you a question? Can I ask you this question very quickly? Sorry, Mr. Falola, I'll come back to you. Just hold on, be patient. But can I ask you this question, Mr. Zikora, if you can hear me?
I don't want him to mislead the general public.
Mr. Zikora, if you can hear me, the Court of Appeal actually gave judgment against your candidate and made a consequential order. That order has not been set aside. Even though the case is before the Supreme Court, don't you think the judgment of the Court of Appeal is still the valid judgment and the valid law and should be obeyed, at least until it is set aside?
I'm not hearing you.
All right.
If you're hearing me.
Yes, I can hear you. Yeah.
It says that even though the subsistence of appeal against the decision of a lower court will not operate as a stay of execution, it may amount to contempt of the appeal court for the lower court to proceed with the enforcement of its judgment during the subsistence of the appeal, the fact of which the lower court is seized of.
Okay.
So
let's just quickly take a break there. We'll be right back.
Listen, sir.
Yeah.
Listen, DEJI. He said we are of the opinion that it will be clearly undesirable that a judge in the court below who has proper notice of an appeal of this to this court should nonetheless proceed with the case in disregard of such notice.
Okay, let's quickly take a short break. We'll be right back. We'll take a short break and we'll be right back. Stay with us, don't go away.
Opinions are free, facts are sacred, but truth is universal.
How, in practical terms, can we, for instance, de-escalate the tension?
President must see himself as the President of the Federal Republic.
We know where the enemy is. 3 places. The Lake Chad Basin, the border area between Nigeria and Cameroon, and then the Sambisa Forest.
On DEJI360, we give you a complete dose of everything. Opinion, facts, and undiluted truth.
I hardly believe what politicians are saying in this part of the world.
A new Nigeria is possible, a future is possible.
We delve into the issues, dissect it so that you can understand it, and use it to take action.
I don't think there's any need for any governor to look for grant for ranching.
DEJI360, dissecting the issues.
Welcome back, and if you've just joined us now, you're watching DEJI360, and we're discussing the Imo North Senatorial District by-election. Now, the controversies arising from the election. The case is still in court at the moment, and there's no one representing Imo North Senatorial District in the Senate. Over 5 months, or close to 5 months now, after the election was conducted. I still have Oseloka Zikora, who's a spokesperson of the Frank Ibezim campaign organization, and I also have Tunde Falola, who is counsel to Ifeanyi Ararume. Both men, of course, Zikora joining us via Skype, and Falola joining us from Abuja. Gentlemen, thank you very much for your patience, but let me go to you, Mr. Falola. You look at what we have at the moment. The decision of the Supreme Court of February 5th, 2021 now, ruling against your client, and we have the judgment of the Federal High Court, March 18th, 2020, ruling against, of course, Frank Ibezim. On the basis of those two judgments, the PDP is saying that the APC had no candidate in that election. Don't you think the PDP has a point?
Thank you very much. Let me correct some misrepresentation in his earlier submission. Our matter was never a pre-election suit. It wasn't, a matter that fall under the jurisdiction of an election tribunal. I say this because what we are challenging is not the primaries properly so-called. We are challenging the refusal of INEC, INEC to issue certificate of return to our clients. Election has taken place. And again, we are not challenging, the return. We are not saying, okay, this party did not score this, or this party was not qualified. No, issue certificate of return to our clients because you haven't declared them as the winner of that election. You are bound, you are statutorily bound to issue certificate of return, whichever way, from which angle you look at it, is neither a pre-election matter or a matter that falls under the jurisdiction of a election tribunal. Because you can't be challenging ourselves that we have been declared as the winner of the election. Can we go to election tribunal and be challenging our own victory? No, the answer is no. A party has been declared as the winner of that election, which is APC. So what is left for us is to activate the jurisdiction of the Federal High Court to compare INEC. Obey the law. This is the position. Order certificate of return. You have declared us. We have, secured the majority of lawful votes, and we have satisfied the provision of the law.
Issue certificate of return. To my question now.
Now, on the issue of PDP, on the issue of PDP saying there is no candidate, I think that question, does not arise in the first place. Because number one, as of today, the judgment of Honorable Justice Taiwo, that affirm the candidature of our candidate.
I understand. You keep talking about the judgment of...
I'm coming.
You keep talking about the judgment of Taiwo. What about the judgment of the Supreme Court of February 5th?
Take your time and read that judgment of the Supreme Court. Supreme Court never said our candidate was not the candidate, our client was not the candidate of APC at that election. Supreme Court never said that. Supreme Court only resolved the issue of, you refuse to join these people. So on the issue of PDP, PDP cannot, enjoy the benefit of anything. The judgment of Honorable Justice Taiwo is a judgment in rem. It's binding on every person. It's binding on the whole world, including INEC and even PDP themselves. So until it is set aside, until it is set aside by competent, which is unlikely, like a competent appellate court. So there is nothing for PDP to jubilate about because our client participated fully, throughout the process of the election. And I declare the party APC, as the winner of that election, haven't scored majority of lawful vote and haven't satisfied the provision of the law. So issue us with the certificate. So there is no, it is, the way, some people are carrying or are propagating this issue that make it as if it is confusing. Okay. There is no confusion as far as this issue is concerned. There is nothing for PDP to jubilate about. I understand
your point. Let me get the opinion of Zikora on that issue. What's your take on that, Mr. Zikora? The position of the PDP.
First of all, DG, I'd like to correct the impression that he's made. He has asked a question. He has said that they never came to Justice Taiwo as a pre-election matter. Okay, well and good. Fine. However, Section 133, subsection 1 of the Electoral Act says no election and return at an election under this act shall be questioned in any manner other than by a petition complaining of an undue election or undue return presented to the competent tribunal or court in accordance with the provisions of this Constitution or this Act. And they defined what this court or tribunal meant. They say in the case of presidential or governorship election, the Court of Appeal. And then in the case of other elections, it says the election tribunal established under the Constitution. Therefore, I do not understand then why they could go to Justice Taiwo, and Justice Taiwo sees the law. What the law says, that no election and return shall be questioned in any manner, and yet he entertained it.
Mr. Falola, I will come back to you. You will have your time.
He is a politician. He is a politician. So what he's presenting here is politics. He's not talking law. He's not talking law. We didn't challenge any election results.
Mr. Falola, I understand your point. Just hold on. But let him have his say. Then you would have yours as well. Let him have his say.
I'm not too sure you understand his point because the law is clear. The law is so clear that it is not meant for only lawyers to be able to know what the law says. It meant for ordinary people who are able to put one or two things together.
Can you answer my question, Mr.
To be able to arrive at
Mr. Zikora, can you answer my question? What is your take on the position of the PDP?
As to the PDP, yes, I'm coming to that. As to the PDP, the Court of Appeal on December 4th set aside a judgment that erroneously made Ararume a candidate of the APC for a few weeks, he set aside that judgment. So that judgment was set aside in its entirety, which means that it never happened. Therefore, as of December 5th, the candidate of the APC, which the court has set aside a judgment that erroneously removed him, first of all, from the ballot, was Sir Frank Ibezim, and the APC's candidate contested that election as the APC candidate. Therefore, there was no issue as to who the candidate of APC was. The issue of disqualification, nonetheless, is something that is an ongoing litigation that I said. And until the final court pronounces a judgment on that, that judgment of the Federal High Court cannot be held as the ultimate. No. Let's wait until the Supreme Court pronounces whether Frank Ibezim allegedly presented false documents to INEC. That will be clear. Once the Supreme Court rules on that, then there is no other issue as to that issue of disqualification by a Federal High Court. Therefore, the PDP cannot say that APC does not have a candidate. No, the APC had a candidate. The APC's candidate was restored, that is not even restored, was deemed as a candidate by the setting aside of the erroneous judgment that took him out in the first instance. And that judgment of the appeal court was affirmed by the Supreme Court on February 5th, which means that the matter is settled as to who the candidate of the APC for that election was. So that is it. So there is, like you rightly pointed out, Senator Ararume went there asking that he be declared. Of course, the Supreme Court never listened to him. Rather, the Supreme Court dismissed his cross appeal, dismissed his appeal at that place, affirming the judgment of the Court of Appeal. And that judgment of the Court of Appeal is Ringham's judgment erroneously removing Ibezim is null and void. It was set aside in its entirety.
It's always
in its entirety.
It's always a tough thing to discuss. You know, political cases involving the courts. But we have to end this. We have to end this now. Let me just, for just 1 minute, give Mr. Falola time now to respond to some of the issues that you raised. Mr. Falola.
Yes, thank you very much. What I want to state, as at today, the judgment that is subsisting is the judgment of Honorable Justice Taiwo, which affirmed our candidate as the candidate of APC in that Imo North Senatorial by-election. Then secondly, as at today, Frank Ibezim stand disqualified. But there is no any superior judgment. That judgment of Court of Appeal, our family's disqualification, has not been set aside. So can you place something on nothing? Right. Someone that said right from day one he was not qualified to contest, to have even participated in the first place. Then secondly, the question you asked my friend is, did the client, did he participate throughout the process of the election? The answer is no. Our candidate was number 5 on the list of the final list of candidates as issued by INEC as of November 2020. So if his client has been disqualified and affirmed by the Court of Appeal, so what is it trying to say? Unfortunately, you didn't link up with their lawyer because if their lawyers have been here,
unfortunately, there's no way we can exhaust this. And
let me respond, DEJI. My response is that you cannot stand something on nothing. That's Senator Ararume was never a candidate. The Court of Appeal set aside the judgment that erroneously brought him into the ballot. And on the last take, if you go to INEC website, you will find that Senator Ararume's name was not there. The people causing this confusion is INEC. INEC ought to have respected the judgment of the Court of Appeal and known that the issue of disqualification is an ongoing litigation which will be settled at either the Federal Court of Appeal or the
we just have to wait. We have to wait and see how this is eventually settled by the courts. But it's just unfortunate that we're having this back and forth now from the courts because it's unfortunate in the sense that the people are losing their own voice now in the Senate. So the hope is that this will be resolved as quickly as possible. It's actually a bad thing to have a situation where the people of Imo North would not have any senator at all, 5 months after they cast their vote in that election. It's really bad. Let's just hope that this is resolved as quickly as possible. But with the way things are going, it appears we still have more legal battles ahead. Gentlemen, thank you very much for coming on the program and, of course, for your time. Oseluka Zikora is a spokesperson of the Frank Ibezim campaign organization. And, of course, he joined us via Skype. And Tunde Falola is a counsel to Ifeanyi Ararume, who joined us from Abuja. Thank you, gentlemen, for coming on the program. Well, too many problems with politics, and let's wait and see how the court resolves all of this. Of course, the outcome of that Supreme Court case would be very, very fundamental to what happens to the people of Imo North and what happens to that by-election in Imo North Senatorial District. Quite interesting and quite intriguing, no doubt. Well, I'll see you again next week. Bye-bye.